Afternoon or evening, wherever you're tuning in from. Welcome to our event, Modern Disputes Management and Arbitration for Competitive Economies. My name is Dr. Sara Razai, and I'm going to chair this very interesting event, which is hosted by the British Institute of International and Comparative Law and the Istanbul Arbitration Association. The aim today is to tackle dispute management and arbitration comparatively and from several angles, which is informed by the expertise of our panelists. What are the foundations for successful arbitration? Should dispute management systems be flexible? And following the COVID-19 pandemic, how can a more conciliatory approach to contractual disputes be adopted? These are some of the topics that we will cover today. I'm joined by Helen Dodds, Director of Legal UK and member of LawTech UK, Commercial Dispute Resolution Task Force. Helen is an international lawyer. She's the former global head of legal dispute resolution at Standard Chartered Bank, and a prominent international bank with a focus on emerging markets in Africa, Asia, and the Middle East. She's a former non-executive director of the London Court of International Arbitration, a leading international arbitration body. We're also joined by Mehmet Gun, attorney Mehmet Gun, who is the founder and chairman of the independent think tank Better Justice Association and the founder of Gun and Partners. He's also the founder and chairman of the Istanbul Arbitration Association, the vice president of the Turkish Enterprise and Business Confederation, and a member of TUSAID, the Turkish Business and Industry Association. Mehmet has an impressive professional track record. Legal 500, Chambers and Partners, and Euromoney rank him among the most influential lawyers in Turkey. Last but not least, we're also joined by Qian Bao, who practices as an independent arbitrator and mediator, and has previously practiced as counsel at international law firms in Hong Kong and New York. Qian is the vice president of the International Chamber of Commerce, Court of Arbitration, and chair of the ICC Commission Task Force on Alternative Dispute Resolution. Between 2010 and 2018, she served as a Secretary General and then council member of the Hong Kong International Arbitration Center. Well, without further ado, so Helen, Mehmet, and Qian will be talking us through some of their own experiences and offer valuable insights about dispute management and arbitration. Now, if you have any questions throughout the event, feel free to type it on the chat, and we will try to take a selection of those questions towards the end of the event. And without further ado, I'll hand over to Helen. Helen, please go ahead.
Well, thanks very much, Sarah, and good afternoon to everyone. I'm very honoured to be invited to speak at this prestigious event. So, the concept of revisiting traditional dispute resolution and management norms, which have historically tended to veer towards the adversarial, came into focus during the COVID-19 pandemic as part of the way in which the legal community felt it could contribute to the minimization of adverse economic impact. So some, of course, of the COVID-19 issues have now abated. But today, as we face new economic challenges, I believe that the suggestions we came up with in connection with COVID-19 are as valid as ever, if not more so. In April 2020, if we can cast our minds back to then, at the start of the pandemic, a concern arose among business and legal communities that as supply chains broke down and legal disputes consequently emerged, courts around the world could become overburdened by a deluge of litigation, made all the more severe as the courts accumulated backlogs themselves attributable to the pandemic. Governments and courts around the world sought to address this in a number of ways. And in fact, some courts, such as the English Commercial Court, were successful in moving online very rapidly. But this COVID-19 catalyst gave rise to a re-examination of the ways in which legitimate commercial legal disputes should be managed and resolved. So in April 2020, a number of eminent international lawyers met under the aegis of the British Institute of International and Comparative Law, ICIL, to discuss the private law response to the commercial and economic challenges posed by the crisis. They produced a one-page note, Concept Note 1, which called for a pause for thought by the business and legal communities before launching into aggressive litigation in response to the supply chain strains caused by the pandemic, and encouraged a legal environment conducive to optimism and global recovery. This Concept Note 1 was followed by Concept Note 2, a wide-ranging but concise review of the private law issues thrown up by the crisis. And then to complete the series, Concept Note 3, now known as the BICL Guidelines, authored by me with Guy Pendell and Adam Johnson KC, was published in late 2020. This took a practical approach and set out practical ways in which legal and business communities could respond to the pandemic in ways that would foster and not undermine economic recovery. The guidelines have also been the subject of an ongoing podcast series produced in collaboration by BICL and CEDA, the Centre for Effective Dispute Resolution. All the concept notes can be accessed via the BICL website, where the guidelines are published in 9 languages, although I'm sorry to say not in Turkish, and the podcast can be accessed via the CEDA website. So today I'd like to focus on these guidelines, which are targeted at the business community and which aim to provide a roadmap to constructive dispute resolution in commercial situations. And we, the authors, would like them to become a point of reference for the business as well as the legal community. We propose 2 main approaches to deliver the objective. 1, to avoid formal legal proceedings where possible and seek resolution via alternative dispute resolution of various kinds. And 2, where formal legal disputes are unavoidable, to conduct these in a way that minimizes the adversarial approach and maximizes cooperation and a constructive approach. So they are a set of voluntary practical guidelines. Our aim was to create something simple, clear and flexible that could be used by businesses throughout the world in any jurisdiction and which would be compatible with any legal dispute resolution system. And at the time of COVID, aligned with a range of international government initiatives. The guidelines aren't intended to be a code of conduct that must be signed up to. Rather, they can be adopted in whole or in part, at will, by one or all parties, and where relevant, their litigation funders, on a case-by-case or more general basis. They're intended to enable the parties to think beyond formal legal system parameters, rather than being constrained by these. They shouldn't be weaponized or used to disadvantage other parties. And we expect them to be of most relevance in the world of commerce. And so we focused on contractual relationships, but they could apply to a wider range of disputes. For example, they may be useful in cases involving economic torts, such as procuring breach of contract and fraud, and issues such as mis-selling and misrepresentation. So we want them to encourage a more conciliatory approach to contractual disputes by prompting parties to seek out and explore the many alternative dispute resolution options that are already available. These include mediation, conciliation, early neutral evaluation, expert determination, and of course, arbitration and med-arb. We hope they can provide a roadmap for those less familiar with managing disputes, helping them to understand the options open to them to resolve their problems and to realize that they are not inevitably headed down the road to court. For example, smaller businesses may find that they have legal disputes with other parties with whom they may have previously had very good business relationships, and may be looking for guidance on how to address the disputes while still preserving those good relationships. The guidelines seek to avoid or minimize protracted legal disputes by encouraging parties, when they do have more traditional disputes, to manage these in speedier and more focused ways. And they encourage the management of legal disputes in a manner consistent with ESG principles, focusing on the G for governance, and asking companies to think about how dispute management fits into their good governance processes. They are clear that they preserve the parties' legal rights. No rights are given away on using the guidelines. There's no compulsory element. The spirit of the guidelines is about making constructive choices. And we believe they are complementary to existing corporate procedures or regulatory requirements and expectations. So as opposed to smaller businesses, larger businesses that are accustomed to legal disputes can use the guidelines alongside their own internal dispute management codes and processes. And many large corporates, conscious of ESG and their reputations, will already have internal processes that focus on efficient and appropriate dispute management. And these guidelines are designed to complement and not replace these. And the guidelines are peer-reviewed by Legal and Business. So before we publish them, we ran them past in-house counsel in a number of sectors, including financial services, oil and gas, engineering, food and drink, and communications, and also past legal consultants. So I would maintain that the shocks of COVID-19 may be somewhat diminishing, but given the new economic shocks that have arisen in part as a result of the situation in the Ukraine and the energy crisis, I would argue that the guidelines really are relevant and apply as much now as they ever did. Thank you.
Many thanks, Helen. And yes, I definitely agree with you that the guidelines' relevance go beyond the COVID-19 pandemic. And it's an excellent practice, good practice of rules that can be applied internationally. And hopefully will be translated into Turkish at some point. And on that note, please, Mehmet, the floor is yours.
Thank you, Sarah. Thank you, Helen. Very nice presentation. I have two hats, as Sarah explained. One is Better Justice Association, which is my heart. The other one is the head of Istanbul Arbitration Association. And I find these two hats complement and complete each other, because I believe arbitration is probably the most advanced civil dispute resolution mechanism that we have now. Together with Better Justice Association and Istanbul Arbitration Association, our aim is actually to improve Turkey's conditions and environment for dispute resolution. And we would like to go much beyond the concept of dispute resolution, realizing that actually the disputes are the dynamics of the society and provide the best means to improve the society. We would like to adopt a policy, and we would like our country to adopt a policy of dispute management rather than dispute resolution. Because if we take only dispute resolution as a concept, then we are comparting it from, the rest of the life of a dispute. So we would like to we have developed a policy and recommendation. We would like our country to develop this dispute management process and use the arbitration as one of the tools within this concept. We realize that the state courts would have a lot of role to play to improve both dispute management process and dispute resolution, amicable settlements, as well as ensuring that the society, in case of disputes, when people are more, egotistical and try to bypass, certain rules and regulations and the values of the society, we would like the courts to actually play a role of peacekeeping process, so to speak. We would like the state courts to actually preserve the disputed interests so that the parties cannot get away with, being smarter than the other. We would like also the courts to ensure an orderly disclosure of facts and evidence between the parties but leaving it to the parties to control the speed and the timing of disclosures. So at the same time, preventing abuses by any of the parties. And the other function that we would expect the system to provide is actually to facilitate settlement between the parties, amicable settlements between the parties. In order to do that, maybe encouragement, maybe incentivizing the parties to come to an amicable settlements could be used. In addition to the tools that Helen has described, mediation, conciliation, dispute adjudication, etc., all those methods can be used at the control of the parties, abuses being prevented by the system. I convene regular meetings between the business people together with the legal people in Turkey in order to explain the ideas and the solutions that we have developed. I would like to recall one anecdote of a business person telling me that I actually would love to be able to predict, not accurately, but predict what the outcome would be if I go to the court or to a third-party adjudicator. He was saying to me that it was more important for him to find an answer quicker with an so to speak more or less accuracy, but instead of waiting for most accurate conclusion by adjudication process. So we thought that in our policy recommendation, we thought that the best thing for the whole system could provide for the parties, disputing parties, throughout the process. From the moment a dispute, a difference of opinion arose that is capable of ending up in the adjudication process, be it state courts or be private dispute resolution institutions or ad hoc arbitration. From the moment it arose, the system should be able to detect, and the whole system should predict what resources will need to be done, and also what preparations, educations, etc., needs to be made available, so that if it is the state courts, they should be able to predict what's coming. For example, in the economical crisis times, the supply chains, the relationships are strained in such a way that people in the normal course of life would be cooperating with each other, but find themselves in difficult circumstances that they have to find a dispute, a difference of opinion. So these disputes are likely to increase depending on the developments, like the war conditions, like the COVID conditions. We have seen this throughout the history. We are seeing this kind of ups and downs of the disputes, the number of disputes that the system needs to deal. So the system should prepare itself. For example, when COVID happens, they should be able to tell in 3 years' time we might face so many court cases, so many arbitrations, etc. But as and when that happens, they should have resources available, ready to take on and quickly resolve disputes. In any event, you would prefer, the system, even the arbitration system, to leave the parties free to amicably settle their disputes. For this, and also for the courts to find accurate conclusions to disputes, is dependent on establishing the facts and evidence accurately, but without really exhausting the parties' rights and resources in disclosing to them. So the court system should secure that the parties disclose to each other the truth accurately, also produce the relevant evidence throughout the process before it ends up in the adjudication process. The procedure that the parties needs to follow should be so simple that, everybody should very easily, find their way to make a disclosure, even, without having to consult a lawyer. Of course, it is most important that the adjudicators, be the arbitrators, be the experts, or adjudicators, dispute adjudicators, as well as the state court judges, need to be need to have utmost integrity. So this system should secure all these in good quality, so that disputes can be resolved by amicable settlements between the parties without having to resort to the final dispute resolution process. But when they are obliged to go to that last resort, then that last resort should be able to very quickly resolve the dispute, because by then all the evidence, all the facts would have been disclosed and collected, so that the dispute resolution system only needs to deal with legal arguments and assessment of evidence. So this is what we propose Turkey to adopt, and I hope our ideas will be helpful for the international arbitration and commercial world, as well as there may be some inferences for criminal and administrative dispute resolution mechanisms. Thank you very much.
Many thanks, Mehmet. And yes, absolutely. I mean, your policy of dispute management really does touch upon rule of law questions that I've also seen when it comes to your policies about reforming the judiciary in Turkey. So let's hear a little bit about Can's experience, and you've been involved in a lot of arbitrations and mediations. And I'm particularly interested, and I'm sure everyone would be interested in hearing about your experiences in Asia as well. So please, the floor is yours, Can.
Thank you very much, Sarah. And it's very nice to hear Helen and Mehmet's comments, which I fully agree with, and I'm very grateful for their interventions. My perspective, of course, is from Asia, but as a U.S. citizen, I have lived in the U.S. as well, grew up in the U.S., and I have spent some time in Europe as well. So I do have, I'm currently based in Asia and have more practical experience here. But I can have, I suppose, the comparative perspective as well. In short, I think that we've really Helen and Mehmet has given a really great context as to the moment in which we are at. We are truly at a crossroads. We've discussed the issue of post-COVID and the needs of companies. And from a practical perspective, we are in a true moment of inflection for dispute management systems. And Mehmet has really indicated and emphasized what the courts are facing and what adjudicatory systems are facing from the users. And we are, in short, identifying the moment of the breathing space and the need for tailored, bespoke programs for companies that have different needs and require different ways in which to resolve their bespoke problems and their bespoke disputes. Helen has also mentioned the issue as to minimizing adversarial systems. And I think certainly in a traditional world that we live in, where adversarial systems are almost all we know, we are at that inflection point where there is a need to take pause and reflect on whether these systems truly work for the users that are engaging in the systems. And in this regard, I can say that we are at a point where we can make real change in being the fact that we are all dispute resolution specialists, and we may major in litigation or arbitration or mediation. But the reality is that we have created these constructs for ourselves to silo us into these forms of dispute resolution that may or may not really meet the needs of the companies and the users themselves. And so if our starting point is not at the dispute management system level, but rather at the company and the users level, then from there, we can understand, what does the user need? What does the company actually need? And in that regard, when we're looking at that perspective, my personal experience has shown that what we need is to understand timing, the issue of timing and the importance of timing in which to interject a third party or not a third party, and interject the possibility of resolving disputes from an external perspective rather than an internal perspective. And so when we start with the dispute, the specific dispute at hand, and we look at the inception of the dispute, when we don't even have the terminology of dispute as the definition of what that conflict is, we look at when that moment becomes escalated to a point of no return. And so we want to be able to be in a position to prevent that tipping point for that conflict. And so the reality of the concept of the breathing space and the concept of all these terminologies that we've overlaid into the practicality of a fight between two companies or multiple companies, and the impasse at which they are at, in which in one trajectory will lead them to continuing relationship and a prosperous, fruitful engagement, and the other may end in a dead end. That is the inflection point in which we find ourselves at, in terms of finding the right moment in which to inject in a dispute resolution, the dispute management system. And in that regard, I think that if we can find, as institutions, as adjudicators, in the way of education, to get to the companies when the inception of the impasse, that timing, that moment, and start to engage, to resolve and diffuse the situation, that is the moment when we can prevent many of the systems that or many of the flaring up of the systems that we've talked about in terms of arbitration and even mediation, but certainly arbitration and litigation, which of course is the true adversarial system. And so in that regard, I think that a lot of our focus should be concentrated on the dispute prevention and the lack of the minimization of escalation of a dispute. And I think that certainly what we've done at BICL through Helen's good work of the breathing space facilitates that. But that conversation and that education must continue in order for us to really give companies the tools to be able to not flare up or minimize the flaring up of a dispute resolution, of an impasse that ultimately turns into a dispute.
Thank you very much, Shannon. Yes, I think that you touched on an extremely important point when you were saying about siloing in, and in a way, it's almost like we have to go back to the basics, right? And the primary unit or the primary focus is the dispute management, and how do we approach it from there, as opposed to what we're doing now. And yes, I also agree with regards to the BICL guidelines and that breathing space. We're seeing more information coming out and more dialogue about, okay, so where do we take it from here? And do we involve it? How do we involve the dispute, or how do we approach the dispute from a different angle, because the past hasn't really worked that much. I think just generally, I'm going to throw a couple of questions out there for you guys, and whoever wants to go ahead. But I think, do you generally, the three of you, do you think there's a tendency for specialists who are involved in a lot of arbitrations or mediations to try and force their preferred form of resolving a dispute instead of looking at dispute management in the round.
Helen?
So maybe Mehmet, yes, please go ahead.
Oh, I meant Helen.
Oh, sorry. Oh, Helen, please go ahead.
So when you say specialists, Sarah, do you mean the arbitrators, or do you mean the practitioners, the representatives of the parties, or do you mean both?
I mean both.
Okay. Yes. Well, and I think to me, a well-run arbitration is one where the processes are constructively engaged, agreed and engaged with by the parties. And if it's working for the parties, unless it really is something quite outrageous, I think it is, and outside the rules, because obviously you always have the rules. It's that the arbitrators should probably allow the parties, if they agree with each other, or there may be more than two parties, to chart their own course on the processes and how they want to do things in terms of disclosing documents and bringing witnesses and so on and so forth. Some people will have, there are people who are very, very expert in arbitrations. They will have had their experiences. They will have views on what's worked for them in the past. What I would caution is that, the past is the past, and you were dealing with company X. In this new case, you're dealing with company Y. So please do keep your eye on the instant case, I think, as specialists, and don't always just reach for something that worked before, because it might not, and you might not be able to force it into that box. As far as arbitrators go, I think the parties often select arbitrators because they think they know what they're going to get from the arbitrator, and the arbitrators will have certain views on certain topics and certain ways of doing things. I'm not sure there's much you can do about that, particularly if the parties have put them in the frame to do that. But again, I would just ask that arbitrators have an open mind and look at the situation in front of them, as opposed to the 99 arbitrations they managed before.
Thank you.
Yeah, I would like to add some developments in Turkey that government has had some success in successfully mediating a lot of labor disputes, and the business community has found a way of, securing crystallized liabilities against the employee claims. So as a result of that, the government is really trying to push compulsory mediation in almost all kind of litigation. This is a tendency here in Turkey I quite oppose, but it is a reality that's going in that direction. I'm not sure when they're going to realize that making it compulsory without preparing the conditions for mediation is going to be successful. I'm going to give an example through life, because throughout my life, all the disputes that I have seen, only a quite small part of the dispute relate to different interpretations and the conclusions of legal provisions when they apply to the to the facts. Majority of them is because the parties, until they pass the point of no return, as Chan put, they did not realize, they did not appreciate the full facts of their dispute, so they learned it after they passed the point of no return. In my example on the Fleet Street, there's an arbitration center, maybe a conference room that we use for an ad hoc arbitration in the UK. This was a dispute between a Turkish businessman with an UK business entity. And the contract was drawn up by an American lawyer, and these two lawyers drafted it. The senior lawyer entrusted drafting certain formulation in the contract to the junior lawyer. At that time, we did not have this, other than telex, we did not have facsimile, we did not have email, we did not have internet. So the junior lawyer wrongly formulated, wrongly expressed the formulation in the agreement, and the relationship between the parties was so good, so they did not have any dispute until 20 years or so later. So when they realized this dispute, although there was not an arbitration clause, they agreed to do the arbitration. So we went through a lot of preparation. We went to arbitration after 1 week of oral hearing. At the last day, it was realized, or the Turkish party realized, that there was this formulation error in the expression of the formulation in the contract. But he did not realize it. At that point, he said immediately, let us settle. I did not realize it. The difference was that, throughout the preparation period, the disclosure between the parties was faulty to my mind, because the Turkish party did not have a culture of disclosing everything to the other party. The other party, of course, coming from a common law culture, were in possession of good file records and all the communications. So to be able to discover and tell that the junior lawyer had made a mistake. So what we are proposing here is that, of course, people would have differences among themselves. Before reaching to the point of no return, the people should have all the facts and evidence available to them. They should honestly disclose all of them, so that they can get rid of all the disputes. Maybe 80% of the disputes relating to the factual situation, etc., could be discharged with amicable settlements in time, so that we do have real disputes. We do have real, answers to those real questions, so that we can advance the law. But until then, we will be, clogged with too many disputes to be resolved, and we will delay. As we delay, then we will be making a lot of mistakes and not really serving the people coming to us for our service.
Thank you. I'll ask another question with regards to that, because I feel like, Mehmet, you're touching a lot upon the Turkish context. How important are cultural or social norms in each of your regions, but also more internationally, maybe, when it's regarding when it's deemed appropriate to get a third party involved to help resolve a dispute? Maybe Can, if you can elaborate on that.
Yeah, certainly. I'm happy to speak on that point. Before I do, I think it's important for me to, I'd like to kind of reflect briefly on what Helen and Mehmet have indicated in relation to our existing dispute management system. Until we can create bespoke systems for every company, the reality is that we have the systems that we have, which include, of course, litigation, arbitration, mediation, and adjudication, of course. And in that reality, I think that one of the things that we can do with the existing systems is, as Helen had mentioned earlier with regard to breathing space, is allow for the existing systems such as litigation and in particular arbitration, where these existing adversarial approaches, the adjudicators that are involved with it, and also the institutions can carve out or create space. And that is in the way of timing, in the way of process, by which to allow for companies to really get the space and the context in which they need to resolve their disputes on their own or through the light touch of an adjudicator. Now, in relation to the cultural aspect, certainly I think that we all come from different cultures, and I think that that's one of the beauties of cross-border dispute resolution and arbitration is the common form of dispute resolution in that context. Culture and tradition cannot be underestimated when we talk about dispute resolution. It is oftentimes something that is taken for granted. We can look at a plain vanilla dispute on the paper, but once you add the culture aspect to it, there are many nuances that can be underappreciated and indeed taken for granted as an adjudicator, as an institution, as a dispute resolution management system. Where companies come from, their heritage and their culture is something that institutions, adjudicators alike must take into account when dealing with how to resolve the dispute, as well as the result and the outcome and the ultimate rendering of the decision, judgment, or otherwise award. And this is an area that certainly has been talked about to some extent, but I think has not been scientifically diagnosed in a way that I think would facilitate more efficient resolution of dispute resolution. There are many things that are unsaid because of culture, because of lack of appreciation as to what traditions and how communication systems work within companies, within amongst colleagues, that can disintegrate once a dispute or impasse arises. And so in this regard, as an adjudicator, as institutions, it really behooves us to understand, or at least give credence and acknowledgement to these issues, so that we can then take it to the next step and begin to engage and understand and appreciate how these nuances might impact the dispute at hand.
I couldn't agree less, Can, because I have seen a couple of examples. One example, of course, this is a Turkish party with an international party arbitration. In one of them, it was a private person selling his company and trusting the other party's lawyer a lot. And he had sent an email to him saying that, older brother, you take care of me too. So older brother has a meaning in Turkish. That means that older brother takes care of everything, not only himself, but also the younger brother. So based on that single evidence, it was not my evidence, but the other party's evidence, the arbitrators was a Swiss arbitrator. He was familiar with the differences, so he held that evidence in our favor. It was very good. On the other hand, I had another client who was brought up in Germany, studied in Germany. He came to Turkey, set up a business. By the way, I should tell you that German engineering has a lot of reputation here. So he said, if I buy a system from a German company, it would be wonderful, no problem, not at all. But the system did not work. But this time, the arbitrator panel said, this is a commercial matter. We don't take into account your trust on German system. So the client lost the case based on that one. So these international cultural differences, the party is giving different meanings to even words and concepts. Even we use the same word, but we understand different things. So for the arbitrators to understand this, they need to really be familiar with the cultural differences in international arbitration. At the same time, the common law system of preparedness for a dispute and the continental law system of being preparedness and the discipline in doing business differ so much that, one feels that, because of that cultural or disciplinary differences, you may be in advantage or disadvantage. And I agree with you that international arbitration needs to improve in these areas.
Yeah, I found in ADR that it's very important to take cultural context into account. And I may make some broad generalizations here, and then we may have an international audience. I wouldn't want to offend anybody, but in my experience, for example, US parties in a mediation, say, are generally more comfortable with a US mediator, which fortunately is not a problem because there are very many excellent US mediators. But that, again, and having your opposite party comfortable in a mediation is very important. So, I mean, I would be quite happy to have that situation. Looking at arbitration, you need a country with its own domestic laws that really support arbitration to be successful. And we've seen this happening recently in India, a country which has huge amount of litigation and you know, a lot all over the country. And you would think that people would be seeking alternative means, but people often seem very attached to going to court. But the government has now made clear that it supports arbitration and international arbitration, and you can see this being reflected in court decisions that are then supportive of arbitration. But what the government thinks and what the legal community thinks may be two different things. And I think that at some stage the Indian bar have been quite concerned about international arbitration in the sense of having concerns about it taking work away from them and their domestic bar. I mean, I personally think that's not much of a threat to them, but that is something that has led them on some occasions to oppose the setting up of foreign branches of foreign arbitration institutions in their countries. So you need to take that into effect. So maybe a few years ago, it might have been a bit risky to undertake arbitration underpinned by an Indian seat, but now I think most people feel very comfortable with that. To take as an example, the Ukraine, where I recently worked on a project, I have to say, I'm not brave, not in Ukraine, but in connection with the Ukraine judicial system, and the question of introducing mediation there. And mediation not commonly used and not really trusted socially in the Ukraine. And actually, unfortunately, some people don't really trust the courts there either. I think that's something for the country to think about and address when it hopefully gets to reconstruction phase. But then the government has shown it's behind mediation and just enacted a law encouraging mediation. And then people have preconceptions and say older societies are used to this kind of getting a third party in. And I was told, in China, I don't know what you think, Jian, that this was, just very common and second nature. But I mean, I had a mediation where involving the Hong Kong, and my Hong Kong colleagues had no familiarity at all with the concept of mediation. I have to say in their favour that they learned very quickly and really quickly grasped it and worked it very well and proved to be very, very good at it. But it wasn't something that they, dealt with every day. So sometimes this comes up as a new thing. And I think even, people think laws are very similar. UK law, US law, particularly New York law, are two of the most widely used common law systems in the world. In my experience, they do have similarities, but they also can operate very, very differently. And you need to look at the context that you're in. So I think it's always really helpful. And it's always very interesting and for me and educational to look at the context and try and work out what the context is and what in the cultural concept looks like a successful outcome, either through an arbitration proceeding or in a mediation. And I think that's hugely important to resolving the dispute.
Thank you, Helen. Yes, I absolutely agree. I mean, context specificity, I can't even pronounce that. Context is extremely important. Let me throw out another question. And I'm really interested in hearing your respective experiences of whether companies are now thinking more comprehensively about what they can do to try and manage a dispute before they have to pursue the nuclear option of litigation or arbitration. Maybe we can start off with Chan and then open it up to Mehmet and Helen.
Yeah, certainly I think that companies should be thinking more about ways in which they can prevent pushing that nuclear button and engaging in arbitration or litigation. The reality is that as I'm sure you are all experiencing now in this post-COVID, for lack of a better term, post-COVID world, world, if we are traveling with a vengeance. We are busier than we've ever been, and we're trying to resume a pre-COVID world in a post-COVID scenario where we're online and offline and lateral and vertical at the same time. And so the reality is that one wonders whether companies are really taking that inflection point in that moment of self-reflection seriously, and with the bandwidth that is necessary to really develop a system that allows them to resolve their disputes before they get to the more adversarial level. And in short, I hope so. But I'm not sure whether, in my own personal experience, whether there is the bandwidth to really develop those systems, because ultimately it's all good for one company to develop systems internally. But the reality is that when a conflict arises, there is a lack of control as to how that dispute might manifest and evolve. And so once you have a counterpart involved, let alone a third party involved, you start losing kind of the control factor in where that dispute arises. However, there are many interest points, many inflection points, and I think that it is useful to kind of think about the way in which a dispute might evolve. First, in which the lifespan of that relationship with the counterpart, and secondly, in relation to culture and tradition, the engagement of a third party, the town elder, the senior statesman of any particular culture, in particular in relation to Asia, what that means for that given relationship, and how that external person, the person that is at arm's length from the given dispute, may engage. All of these factors may play a meaningful role in the way in which companies will now look at disputes. And so I think that it is not something that we can kind of trend at the moment. I think it's still too early to see where we will go in this post-COVID world. But I'm hopeful that with the idea and the concept of breathing space, and with the many webinars that we've had over these 2.5 years, companies will start to prioritize and engage with the concept of dispute prevention, dispute resolution, internal systems, looking and reflecting on timing in which to engage an external person or party to resolve their disputes. All of these systems, I think, will hopefully allow for a longer span of dispute prevention before needing to press on that nuclear button, as Sarah, you've mentioned.
Thank you.
I would like to add that domestic entities, relatively smaller than international companies, always engage in dispute management. They're trying to avoid ending in the dispute adjudication process, either in the arbitration or state courts. The local businesses are very eager to go and arbitrate because they suffer a lot in the state court system. My international clients have a tendency of really, taking their time before they resort to dispute resolution mechanism. The point of no return, they are so careful of not passing it without giving really real consideration and the chance for a settlement before that is a real issue for them. Of course, there are, multinational companies, their activities in one country affects their activities in other jurisdictions. They have got to be really, really careful. And I guess most of, the issues that I'm involved with, I'm advising them to manage dispute rather than going to the, dispute resolution system. So in the end, I think it is fair to say that companies are very eager to actually manage their disputes with an objective of avoiding dispute resolution mechanisms.
Yes, I think so. I think I very much agree with what both Mehmet and Chan have said on this. I think in my experience, and this goes back to the breathing space note, it may be slightly different in larger and smaller companies. And I think larger, and I have worked in a very large corporate, and such companies will, because of their size and possibly because of their kind of business, they do have a throughput of legal disputes, which means it is worth their while to internally consider this and produce some standardized processes and procedures, which of course form a base. All large cases are different, but which form a sort of useful base, like and cover things like in common law jurisdictions, how to preserve legal privilege if you want to do that. And have you told the regulators, what are your communications messages, and so on and so forth. So larger companies have, in my experience, had those, and I think they are helpful internally and helpful for setting the mindset. More medium-sized and smaller companies, as Sarah said, do not have the bandwidth often to do this, and they may have a very well-run business, and they might have had a few debts here and there. But they really haven't had a dispute before of the kind of supply chain break kind of thing that is happening now. And I think to them, I'm hoping that the breathing space note is something which they could sort of look at as a starting point for, well, how do we do this? What on earth do we do? We don't have the money, we don't have the time, but we need to, we don't want to spoil our relationships, but we need to resolve this. So I'm hoping that in a way, that is a kind of more off the peg kind of solution for them. And also something that I think might help in future is technology and law tech. And you can get your contract reviewing tools, which can tell you perhaps ahead of time when something might come up that might affect a clause in your contract. So you may be able to have a system where you feed in, goods not delivered, but that was because the goods weren't delivered to our supplier, and so on and so forth, and see what contracts in your what clauses in your contracts might be triggered by that, and then be able to reflect on what's the best way of dealing with that. And I think for the smaller companies which can't have armies of internal lawyers, having tools like that could be helpful in future. And I mean, there are myriad law tech projects now in development that I think could be very helpful, as well as some online dispute resolution systems which are quicker and cheaper. And I'm talking, if you bought anything from eBay or Amazon, if you've had a problem, they have it's a dispute resolution system. It's an online, very basic dispute resolution system, but those are there now. And there are lots of these, and I've worked on a concept for one for small businesses in England, and there are various models for these, and so that might be something that the smaller businesses could turn to. Larger businesses will always want something more bespoke, but that doesn't mean they shouldn't, and that they wouldn't sit and think about these principles. Because what is the object of the exercise? The object of the exercise is not to go to court, roll the dice and spend a lot of money. The object of the exercise is to resolve the problem in a commercially acceptable and timely way so that the business can get on with doing what it does, which is making money.
Helen, I would like to add a couple of examples. One in international, the ICANN dispute resolution mechanism at WIPO is really successful. They have adjudicators from around the world, and they deal with disputes through, in the internet communication, and they really settle it. There is one local example here that all the insurance claims go through an arbitration center. They actually, Insurance Arbitration Center have collected all, good, qualified insurance lawyers as arbitrators. They have really achieved good success, and they've saved a lot of work from the court system.
Absolutely. Insurance, sorry to interrupt, insurance have latched onto this really quite a lot, insurers, I think,
yes,
internationally.
yeah.
They really see the value in it.
Yeah. It is easy to do that. But if you need discovery a lot, then these small claims systems are not suitable for that.
That's right. Horses for courses, I think. Different remedies for different kinds of disputes.
Yes.
Thank you. I'll throw, I'm conscious of the time, so I'll throw out another question, maybe a concluding one. So really keen to hear your thoughts about the future of arbitration in your region or country, or just generally the future of arbitration. Qian, any thoughts on that?
Yeah, I think I'm going to ride off of Helen's note on technology. I know that she's done quite a bit of work in law tech space, but I think that that's an area to watch. There's certainly been, we have certainly seen video conferencing been in our vocabulary for some time, but it really took until COVID to engage with it properly and in a systematic way. But this has allowed us to open up the door that much more in relation to how we utilize technology in resolving disputes. Certainly law firms are getting more competitive, and law firms are now trying to seek ways in which to address the disputes of their clients at the outset. We have, as part of my work on an ADR committee, I've spoken with many law firms that now have departments looking at how to prevent disputes, how to look at decision trees, how to take big data and help their clients really resolve disputes without engaging in the adversarial systems. And so hopefully that's somewhere that we will see more development and more accessible development on. Certain, I mentioned law firms, but many of these disputes that we're talking about are too small to engage in the international law firms that I've been speaking with. And so hopefully we will see more systematic ways in which smaller companies, SMEs can find ways in which to resolve their disputes through, analysis of big data and looking at decision tree mechanisms and systems by which to minimize the ultimate disputes that arise to the level of need for an adversarial system. So gazing into that crystal ball, I see and hope for less disputes through more systematic and thoughtful dispute prevention mechanisms through technology.
Thank you, Qian. Mehmet, please go ahead.
My turn. Okay. I would like to mention that Turkish government is very keen in making Istanbul as an arbitration hub between London, Paris, and other arbitration centers up until Singapore. So there's a huge geography and demography here. We would like to attract the arbitration, and we would like to become a dispute resolution mechanism here. There has been a couple of formal agreements designating Istanbul as the arbitration center. One is Islamic Cooperation Organization have designated Istanbul as arbitration center. And in fact, one is being formed in addition to what we have now in Istanbul Arbitration Center. Black Sea Economical Cooperation Agreement, and also involving the Caucasus countries, Turkic republics, former Soviet Turkic republics, etc. We're trying to involve them in international arbitration. There is already a governmental agreement. At the same time, Turkey is trying to improve the practitioners of arbitrators in domestic disputes, especially, and we're trying to put all the commercial disputes into sort of Portuguese-like compulsory arbitration, although I oppose to it for it being compulsory. But the thinking is going that way. I guess, if we adopt this modern dispute management systems, as well as, allowing this breathing space, all the state of the art, proposals and the concepts in our system, if we can do it, then maybe not in the short term, but in the long term, Istanbul is likely to become an arbitration hub. And Turkey, in addition to Istanbul, would have arbitration hubs in Adana, in south of Turkey, in Ankara, and maybe one in the east of Turkey. We're seeing indications for this one. Every chambers of commerce in Turkey, almost every one of them, is setting up arbitration centers. I'm sure there will be some time that some of them will consolidate into one major ones. So we're going through the dialectic of arbitration centers development in the country. So we're hoping that before I retire from this profession, we're hoping that Istanbul and Turkey becomes an arbitration hub in addition to what we have in the worldwide.
Well, I'd just like to say, in connection with the UK, in fact, the Law Commission was due to come out with some proposals about arbitration, which have been postponed because of the death of the Queen, but we'll see those shortly. And I think what's expected is some constructive alterations to the existing law, but nothing to bring it in line with current international best practice, but nothing more radical than that. I think in the UK, there may be a bit of a shift from kind of litigation that went to the commercial court to arbitration, reflecting some people's, I think, unjustified fears about enforcement, because of course the big advantage of enforcement of arbitration is that that we have the New York Convention, and enforcement is relatively straightforward in cross-border cases. Generally around the world, I agree with Chan. I think there will just be more arbitration as people find the local courts not quite working for them, and seeking out something that stands a bit outside those courts, although, as I mentioned before, hopefully underpinned by supportive law, and other countries may well want to refresh their laws on that to support that. And again, to agree with Chan, I think technology will play a greater part, just because it's technology and makes life more efficient, but also because of things like the Greener Arbitration Pledge. Because arbitrators are absolutely famous for getting on planes at the drop of a hat prior to COVID, and perhaps doing that a little bit less now, particularly on their interlocutory hearings. I think that while there are pros and cons of having the final absolute hearing in person or not, depending on the circumstances, certainly I think for interlocutory hearings, not many people would argue that those need to be in person anymore. So I would expect to see advances of technology one way or the other, and partially in support of an environmental agenda.
Thank you. Yeah, it's certainly interesting to see what the future holds for arbitration globally and regionally, and also in each and every country. I'd like to thank you all for an excellent webinar with plenty of insights and discussion, and plenty of food for thought as well on conflict management and dispute resolution in general. I'd also like to thank whoever participated, those of you who tuned into this, and I'd like to highly encourage you to follow the works of Mehmet, Chan, and Helen in this regard, and you can follow it individually, and also through their institutions. Thank you again, and hope to see more of these discussions in the future. Have a wonderful day, all of you. Thank you.
Thanks so much, Sarah. Thank you.
Thank you.